Right, I think we should begin. We are just over agreed time. And welcome everybody to our webinar on what does Rule 41A mean for mediation in South Africa. We have 54 participants. We're expecting a couple more, so people might be popping in. Let me begin by introducing who you have on the screen with you today. I'm Felicity Steadman. I'm a director in conflict dynamics. I've been a mediator for about 30 years, both in South Africa and in the UK, where I mediate through CEDA, the Centre for Effective Dispute Resolution, and through CEDA on the Court of Appeal panel of mediators. I'm a director in conflict dynamics, and with John Brand, we established conflict dynamics also about 30 years ago, nearly 30 years ago. John, who you'll also see on the screen, is a lawyer by training. He has spent most of his years as a lawyer in the firm Bowman's, or Bowman Gilfillan as it was called, as an attorney, as a partner, as a director, and is now retired and working very closely with us still in conflict dynamics as a consultant, and greatly involved in our work. He's also on the South African Law Reform Commission ADR Advisory Committee, and in that capacity very closely involved in discussions about mediation in South Africa and how the law can accommodate mediation. Craig Huscher, who you can't see behind our Combritum icon there, is our producer or host for the call, and Craig is our administration manager and does all the magic behind the scenes. So thank you, Craig. Our plan for the discussion is that we have a series of questions that I'm going to put to John, and between the two of us, we will address those questions. If you have questions about what we're saying as we go along, please just add them into chat. You'll see at the bottom of the screen, there's a chat function. Alternatively, put them into the Q&A function. So you've got two options to let us know if you have any questions, the chat function or the Q&A. The chat function is more visible to everybody, and the Q&A is not visible to everybody. We just see it, and we will answer them, deal with them as they come up. I'll be watching both those two places, and as the questions come up, if they are relevant to what we're talking about, I'll draw them in. If they are questions that we're coming to later, I'll leave them for later. And if there are questions that we could deal with at the very end when we have some time, we'll do that. So a bit of an explanation of the platform here. I think we're all getting really good at doing this. And so I probably don't need to explain much. But just a few things. In your top right-hand corner, there's an option to put yourself on speaker view, or put us on speaker view, or on gallery view. If you have the gallery view, then you see both of us and also the PowerPoints as we share them a little later. If you put it on speaker view, then the focus is on the person who's speaking. So you can flip between those two at will. We are recording, which is up in the top left-hand corner, as you will see. And I think that's about all we need to really explain. Okay, good. I think let's get going. So Craig, if I could have the first slide, and just to give a little background to how we got to where we are with Rule 41 capital A. So the first point there is as we know, on the 9th of March, 2020, High Court Rule 41A came into effect, and it is an amendment to the rules in the High Court regarding the conduct of mediation in the High Courts. And it's really the first tentative step into the world of High Court aligned civil mediation in South Africa. In many other jurisdictions, such reference to mediation exists in rules already. and indeed in the UK, for example, some of the courts, such as the Court of Appeal that I've mentioned, have mediation panels associated with their functioning. So they're very close to this. Now, I think, as we know, mediation is not a new process in South Africa. Employment disputes have been mediated in South Africa since the 80s. And many of us who've been around for quite a long time will remember the Independent Mediation Service of South Africa, which was established in 1984, a long time ago, and continued until a couple of years after our first democratic elections, when the CCMA was established. And John and I in Conflict Dynamics were involved in training the first cohort of commissioners for the CCMA. And we know that the CCMA mediates more or conciliates more matters than any other similar institution in the world. It is the most amazing platform and forum for dispute resolution. We know also that negotiation, mediation, and facilitation were very strong features of the peace process, leading to our first democratic elections in 1994. And many of the mediators from IMSA were involved in those processes, in the peace process, and have since gone on to take up positions in the judiciary and in many other forums, using the skills that they learnt in the very early days. There are actually more than 50 pieces of legislation in South Africa which reference mediation and conciliation. And so it's happening to a greater or lesser extent in many different forums. In 2014, the Magistrates' Court rules were amended to encourage the use of mediation. But sadly, none of this background of experience and legislation has really had an impact on the use of mediation in civil litigation. And it's really only with the change to the High Court rules and the inclusion of Rule 41A that we hope we will see the use of mediation in that forum and in the case of civil litigation. So I'm going to start, if we go, thanks Craig, I'm going to start with just having a look at the difference between some of the key processes, mediation, arbitration, litigation, because really we are finding, regardless of this history, this rich history of dispute resolution, we still encounter people, parties, their representatives, people in government at all levels who actually don't quite understand what mediation is. So John is going to talk to a slide, which Craig is going to pull up, and just highlight some of the key differences so that at least we're all on the same page about what mediation actually is.
Thanks, Felicity, and good morning or good afternoon to all of you out there. It really is nice, even in this remote way, to be making contact with you. I want to be very brief about this because I think a lot of you do understand the differences, and those of you who've been on our training will probably remember this slide. But there are just a couple of things that I do want to emphasize. Down in the bottom right-hand corner is our endeavor to depict court, and in the bottom left-hand corner is our endeavor to depict arbitration. And both of those are adjudicative processes. The court, where the judge or a magistrate decides the matter, and in arbitration, where the arbitrator decides the matter. And what's important to remember there is that in those adjudicative processes, the parties hand over the outcome to a third party, for the third party to determine the outcome for them. The other important feature about them is that in the case of court action, the parties have to fit their dispute into a particular cause of action determined by the Roman Dutch law or legislation. And in arbitration, much the same, although there's greater flexibility there to send a broader range of disputes to arbitration. And in the court situation, the kind of outcomes that the courts can give, the the sanction or the remedies are constrained by what the law allows. Again, in arbitration, slightly broader because the parties can determine that, but still fairly narrow. Very important feature of both of them is that they result in a win-lose outcome. There's very little or no possibility for a mutual gain type outcome. We know also that court proceedings are generally complex. The processes are complex. They're very time-consuming. They are very expensive. It's arguable about whether or not it's much better in arbitration, but relatively fairly time-consuming, fairly expensive, and fairly complex. And the process followed in court is fairly rigid. In arbitration, slightly more flexible and user-friendly. But those are the key features of adjudicative processes. And we need to compare that with the two processes above. The first one being negotiation at the top, where, as we know, the outcome is in the hands of the parties. The parties define the dispute. The parties agree on the remedies. The parties control the process. And there is, as compared with adjudicative processes, the possibility of mutual gain, win-win outcomes, and negotiation, depending on the skill of the parties, can be fairly simple, fairly cheap, and fairly quick. As far as mediation is concerned, I think you've heard the phrase that mediation is turbocharged negotiation, where a highly skilled third party comes in and facilitates the negotiation and helps the parties to achieve the ultimate outcome of negotiation. It has the possibility for mutual gain, for win-win, for really super outcomes, and as we will describe later, is generally quick, cheap, and relatively simple. So that is what we need to bear in mind, is that in mediation, the third party does not determine the outcome, nor does the third party advise the parties or recommend. The primary purpose of the mediator is to turbocharge, facilitate sophisticated negotiation.
Thank you, John. What I love about the diagram, looking at it in the context of COVID-19 and online platforms like this, is that you can sort of imagine process number 2 there, like a Zoom meeting. You're all in the middle there, you're all in the main room, and then you've got your breakout rooms. And we've been training our conflict dynamics mediators, our panel of CD direct mediators in online mediation, and that is exactly how they will work on a remote platform. So
can I just come in there a moment? What I think is also very important is that, as I see it, our courts are way behind what is happening in the rest of the world in going virtual at this time. There is some arbitration taking place remotely, but as you've said, one of the big advantages of mediation at the moment is that there's a lot of it going on virtually.
Okay, well, that really leads us to our next question, and that is when to mediate. So Craig, just on our PowerPoint there, we have the question, we've dealt with that one, the difference between the processes, now just turning to when to mediate, fairly straightforward and self-explanatory. And so John, let me begin by asking you, when in terms of Rule 41A, when what does it say about when people should mediate? And I think there's probably a broader question there about generally, when can people mediate, parties mediate?
Yeah, I think it's important to make that distinction that you just made. In terms of the rule, the requirement to consider mediation only kicks in at the time that the plaintiff or the applicant initiates the court proceedings, and then the defendant or the respondent is required to say whether or not he or she or it agrees to mediate. So the time is at the commencement of proceedings, which is a little bit unfortunate. I think that the rule could have been better in that regard, because we know that the move across the rest of the world is to try to get people to mediate as early as possible, prior to a lot of time and money being spent getting to litigation. So the answer to your second question is that, notwithstanding what the rule says, there's nothing to stop parties initiating and asking to go to mediation at a much earlier stage and settling the matter without having to initiate court proceedings, which would be prize number one.
And in the current circumstances of very limited access to the courts, how could mediation help parties?
Well, it gives them access to justice, which they are not getting generally in the courts, excepting for urgent matters. They can they can propose mediation, ask the other side to agree to mediation, and say to the party, if you don't agree to mediation, we are going to place this before a judge at the end of any litigation in our argument around costs. We are giving you an opportunity to come and find a consensual solution at an early stage. And that can be done virtually now through conflict dynamics with its mediators that are trained in that area.
And what happens if the other party says no, either no to mediation, or no, I'd rather wait until the courts are functioning again?
Well, the way the rule is framed is that it says that the parties must consider, must indicate whether they agree to or oppose mediation, and the opposing party must respond by saying, do I agree or oppose? And so, strictly speaking, in terms of the rule, there is no duty to do anything prior to the issue of proceedings, which I think is unfortunate. It may be arguable, as I've said, that the party should have done it earlier, but that is debatable. If they then, to the second part of your question, again, the rule could have been much more explicit. It could have been as explicit as rules and legislation is in many other countries, which states expressly that if you unreasonably refuse to mediate, you run the risk of an adverse costs award being awarded against you. In the present rule, all that it says is that you must state why you don't agree to mediation, or put rather strangely, why you think the dispute is inappropriate for mediation. I say that's strange because there's virtually no dispute which is not appropriate for dispute resolution, for mediation. The question is whether it's appropriate for the particular dispute to be referred. There might have been prior mediation which failed. It may be a constitutional dispute which requires a precedent or whatever. And then the rule says nothing expressly as to what would happen if you refuse. There's no provision that the court can order you to consider it or to go to mediation. All that it says very indirectly is that when the court comes to consider costs, it may take into consideration what you said when you responded to the invitation to mediate. And how the courts are going to interpret that, how the judges are going to interpret that is critically important. Up until now, our courts and our judges, excepting in about 3 cases that I can think of, have been very slow to sanction lawyers or parties for unreasonably refusing to go to mediation. The hope is that by introducing this rule, the courts will be far more activist in encouraging mediation, and if parties unreasonably refuse, they themselves will get adverse costs award, and if a court was to follow the Brownlee versus Brownlee judgment, that attorneys themselves can be denied their party costs for unreasonably failing to do what they should do. But we're going to have to wait and see how the judges respond.
And so even if the rule doesn't mention costs, sanctions, what I think you're suggesting is that by precedent and as judges make decisions like this, such as in Brownlee versus Brownlee, maybe a new tradition will develop, precedents will develop that judges will fall behind.
Yeah, I mean, the role of the judges in this is absolutely central. How they respond to this rule is going to determine whether we enter the 21st century of dispute resolution or we continue where we are.
Okay. Just another point on when to mediate. Does mediation and the decision to use mediation interrupt court pleadings or proceedings? I mean, does it cause a delay, or is it just something that sort of happens alongside?
Well, ideally, it should happen alongside and not delay the proceedings. But for some inexplicable reason, the rule provides that if the parties do agree to mediate, that the pleadings will be suspended effectively for a maximum of 30 days to give mediation a chance. So yes, to that limited extent, they are delayed. Yeah.
Okay, but I'm getting the sense from you that mediation can really happen at any point. So if it happens prior to issuing proceedings, well, it would have no delay impact. And if it happens sort of privately as proceedings are proceeding, it doesn't necessarily have any impact either on time.
Well, there's one, again, strange provision in the rule, which says that once the proceedings start, once the hearing starts, it says you have to get permission from the judge to mediate. And it's difficult to understand why that is so, and whether that is to mediate in terms of Rule 41A, or whether you're free to mediate parallel with the litigation, which often is a very good thing because parties are starting to realize the weaknesses and the strengths of their case as the case progresses. So again, we'll have to see how that pans out.
Okay, so Chris Todd has added a point in our question and answer panel. He says there might be concern that if time periods were not interrupted, this might discourage mediation, and that giving a limited delay gives a short breathing space for mediation. Yeah. Okay, so let's move on then to what kinds of disputes can be mediated in terms of Rule 41A.
Well, the answer to that is really very simple. The rule states that the subject matter, that what can be mediated is the subject matter of litigation between the parties or any aspect thereof. So it's confined to the subject matter of the litigation, or perhaps parts of it, like you could refer quantum to mediation, but not the merits of the case. So that's strictly speaking what the rule provides. Yeah, and it also doesn't stop you now referring whatever you would like to to virtual mediation because the courts aren't effectively operating at the moment.
Okay, so it's a very wide application.
Well, yes and no. I would rather say it's a narrow one because it confines you to that which is contained in the litigation. What we know as experienced mediators is that often the real dispute is not the one defined in the litigation, that the real dispute is something completely different, as is the settlement to that. So it is a bit narrow.
But I think what we know as mediators is once you get the parties in the room, within the framework of an agreement to mediate, there's a lot you can do to broaden the scope of what's under discussion and the scope of the potential agreement.
Absolutely.
So, John, who are the mediators? So tell us a bit about who you think are the mediators that the parties and their representatives should be looking for, and where do they find them?
Yeah, I think that one needs to look at this from two perspectives. The one is from the narrow wording of the rule, and the one is from a wise approach of lawyers and mediators. In the earlier drafts of the rule provided that the mediators needed to be independent, impartial, and neutral, but also very importantly, it stated that they needed to have undergone training, they needed to be competent, and they needed to be certified. Those of us who responded to those drafts suggested that the mediators should be accredited by DISAC, which is the Dispute Settlement Accreditation Council, that all the private dispute resolving parties actually, and the CCMA, have put a lot of effort into setting appropriate training standards, mediator standards, ethical standards, service provider standards, and so on, and that should be the qualification of the mediators. What is very disturbing about what happened when we saw the final rule as it stands now is that they took out the word neutral, left impartial and independent. I don't want to go into the debate about neutrality, but what is very troubling is that there is absolutely no mention of training, competency, or certification. And the fear is that the drafters had in mind that this would enable unqualified, uncertified, unaccredited judges, lawyers, whoever else to mediate. So that is on a strict interpretation of the rule. But I think that what is going to happen is this, that lawyers who are worth their salt, parties who are experienced and knowledgeable, know that you need a really competent mediator, properly accredited, subject to codes of ethics, to ongoing training, and the like, to mediate. And they're simply not going to choose anybody that is held out to be impartial and independent. They're going to themselves opt for such people, and they can be found obviously through conflict dynamics and conflict dynamics direct, but the crunch will be, are they DISAC accredited? I also think that in interpreting that rule, that it would not be unreasonable to refuse to mediate under an unqualified, unaccredited person, even if that person is a judge or an experienced lawyer, to punish a party for refusing to mediate before an unqualified person just doesn't seem to me to be appropriate. And I think the other side of the coin is that if parties put up a accredited, trained, competent mediator, and the other part, or a group of them, and says, choose any one of these that you want, and the party refuses and puts up an unqualified one, that would be an unreasonable refusal to mediate, which, with judges who know the importance of qualified mediators, will sanction the refusing party. So, notwithstanding the wording, I'm hopeful that it will result in conflict dynamics and other accredited mediators getting the work.
Okay. So they choose a mediator, and usually parties choose a mediator out of a couple of names that have been proposed between the representatives and discussed. Who pays the mediator?
Well, there again, the rule is very simple. It says 50-50 unless the parties agree otherwise. And that's generally what does tend to happen. So I don't think, well, the one important thing is that it won't be paid for by the state. And so the parties will be incurring that expense. But I may just say that generally speaking, across the world and in South Africa, commercial civil disputes are settled within a day or two, and to share the costs of a qualified mediator is really cheap at the price compared with what the parties are paying their attorneys and their advocates and all their managers for being there. So it is a very cheap process to follow.
And let's say they can't agree on a mediator for whatever reason, price, availability, isn't someone that they both find suitable. What happens then?
Well, then there's no provision in the rule for that, which is unfortunate, because that will happen from time to time. And generally what parties do in automatic arbitration agreements is they provide a panel of mediators, or say anybody from this panel of accredited mediators. But if the parties can't agree, a respected independent third party will appoint one of those parties. So the parties can do that. But as the rule stands, there's no provision.
So in our experience in conflict dynamics, sometimes parties ask the agency, CD Direct, to appoint a person who would be suitable. So, we would look at our mediators in relation to the dispute, the issues, the sector, etc., and appoint. There's a question which has been asked by Kasahi Naidu. What happens if a party doesn't have the funds to pay? As we know, in South Africa, many litigants who are contingency-based without funds. Yeah.
Yeah, well, there are two things there. The one is that there's nothing to stop one party paying in full for the mediation. And I should just make this point, that used to happen a lot in the IMSA days, where unions couldn't afford mediation or arbitration, but progressive companies wanted their disputes resolved in that way. They would pay. And then the question was asked, but doesn't that bias the mediator? The answer to that is the mediator need not know, because the arrangement is between the service provider, IMSA, conflict dynamics, that they will be paid, and they will pay the mediator, and the mediator doesn't know in what proportion the parties are contributing. So that's one way of dealing with that problem. The other point to make here, in this instance, high court mediation, it's seldom that, well, not seldom, but in many cases, the parties are highly resourced and therefore are in a position to contribute to the mediator's fees. But in the limited situations where you get a totally impecunious mediator operating party operating on a contingency, I haven't got an easy answer.
Okay, all right. Well, we might come back to that later. There's a question about the costs of a mediator, and it varies. We ask the mediators what their fees would be in the particular matter, and they will set their rates, and they range from typical professional fees charged by lawyers and other professionals to lesser rates where mediators perhaps believe that this is a more of a public service in some respects. Perhaps under current conditions they might take that view more frequently, but it varies. And we certainly, when we train our mediators, we say, if you want to get work, be available and don't be too expensive, because cost is often a big consideration.
But I do want to just say, Felicity, that in most of the high-level High Court mediation, 50% of a mediator's fee is a fraction of what the parties are paying for their attorneys and their advocates per day, and a fraction of what it's going to cost them in a week of litigation. So relatively, it is very cheap.
Yeah. Okay. Okay, I'm going to move off the mediator and who they are and how much they be paid to the agreement to mediate. Now, if I think back to the IMSA days, as I recall, there was no such thing as an agreement to mediate, a written down agreement to mediate. There was an agreement that the agency arrived at with the parties about who the mediator was, when it was going to take place, who was going to be paid, paying for what, etc. But there was no express agreement around confidentiality, without prejudice, and those sorts of key aspects of safe mediation, effective mediation. However, we work, certainly in conflict dynamics, on the basis that the mediator and the parties need to enter into a very clear and sound agreement to mediate, which creates a framework for the process to take place within which. So John, tell me, what do you think needs to go into the agreement to mediate, and tell us about that agreement to mediate.
Well, the first point I want to make is it should be relatively easy for the parties. We've put up standard recommended agreements to mediate, which are accessible on the conflict dynamics site. There are examples at the back of our book, Chris, Felicity, and our book on commercial mediation. So there are good standard agreements, and in essence, they need to determine who the parties are, what the matter in dispute is, who the mediator is going to be, how the costs are going to be shared, who's going to determine the process, and very, very importantly, deal with confidentiality and without prejudice, that the mediation is off the record. I don't want to spend a lot of time on it, but it is gives attorneys an important role. Not only can they play a big part in advising clients whether to go to mediation, when to go to mediation, whether it's appropriate, but also to help them settle an appropriate mediation agreement to mediate with the help of the standard agreements. So that's easy, Felicity, if I may say.
Forgive me if you mentioned this, but I don't think you did. The point about mandating an authority, and in the agreement there would also be a clause which indicates that the parties are required to come to mediation with authority, so that it's not a fishing expedition, but a serious endeavour to reach an agreement.
Yeah, I didn't mention that quite right.
Yeah. Okay, so let's turn now to the point, some points around preparing for mediation and what preparing involves. So tell us, John, about the difference between preparing for court and preparing for mediation. What does that look like?
Felicity, it's very, very different. There's one area of overlap, which I'll come to, but it's very different, because what you're doing in mediation is going into a facilitated negotiation. and therefore the preparation is akin to preparation for a sophisticated negotiation. It's not preparation for a court case where you are going to present witnesses, present legal argument, and win or lose. So parties themselves need to prepare as though they were preparing for a sophisticated negotiation. And if they don't have those skills, they need to import those skills. Similarly, lawyers helping parties prepare for mediation need to either have the sophisticated modern negotiation theory and practice skills so that they can help the parties do that, or they need to employ people in their firm or consultants who do have those skills so that you are ready for a sophisticated negotiation, not a court case. And let me just deal with the overlap. One of the important things in any negotiation is what are the parties' best alternatives to a negotiated agreement, or what are their worst alternatives to a negotiated agreement, what are their probable alternatives to a negotiated agreement, BATNA, WATNA, PATNA, and that involves a intelligent analysis, risk analysis of how your witnesses are going to stand up in court, how your arguments are going to be heard by the judge, and what your prospects of success are going to be, how long that is going to take, how much it's going to cost in legal fees, managerial fees, and so on, because that helps you set a parameter in the negotiations. So their lawyers are well equipped to deal with the risk analysis part of the preparation.
Mm.
There's a great deal more that needs to be done, like identifying who all the parties should be in the mediation, what are all of their interests, needs, fears, concerns, how might those be addressed, what are all of the potential options for addressing all of those needs, both theirs and yours, what are the strengths, weaknesses, opportunities, threats. So there's a great deal of preparation along the lines of a preparation for a negotiation. So our recommendation would be that it's essential for parties themselves to have undergone advanced negotiation skills training, for lawyers who represent clients and help them to prepare to have undergone that kind of, and obviously for mediators, because you're not deciding a matter based on law. It's helpful to understand those risks, but it's not the core function. So in summary, that's what I would say, Felicity.
Okay. We have a question, one of our earlier questions I was just waiting to come to, which is about a pre-mediation meeting. So how can the mediator assist the parties get ready before they actually come to the mediation? What role does mediator play there?
Yeah, it's important, and this is one of the things that we do train our mediators to do, is to be in contact with the parties or their representatives ahead of the mediation to make sure that they understand what mediation is, that it's not some kind of mini trial or truncated adjudicative process, that it is negotiation, to make sure that they have a proper agreement to mediate, they know what to expect, what the process is going to be, and that they know how to prepare, that they are preparing for a negotiation, what documents need to be exchanged, and the exchange of documents is very different from the kind of exchange of documents that happens in litigation, whether they want to make a written opening statement, who's going to be present at the mediation, who's going to speak on behalf of the parties. So it is very important for the mediator to engage. And parties have different levels of understanding and skill in this area. So mediator may have to engage a lot more with one party than the other, but the pre-mediation engagement is very important.
Yeah.
I hope that answers the question.
Yes, thank you. We actually talk in our training, as you know, about the mediator as a negotiation coach. And so obviously, totally mindful of impartiality, neutrality, independence. The mediator is really there to help the parties enter into the most effective negotiation they can on the day. So that preparation stage, thank you for that question, Herman, that preparation stage is very important. What about other features of litigation that people might be wondering about in relation to mediation? You know, do you bring witnesses? Is there an interpreter? Is there a recording? How does that all work?
Well, let's just talk witnesses. Generally, it's unlikely that you would bring witnesses as to what happened, but it is quite common to have expert witnesses depending on what is in dispute, actuaries, specialist doctors, and they can be put together by the mediator to try to find common ground. So again, that's why preparation is so important, because you need to know if there are factual differences and opinion differences, that those should be narrowed in the mediation. But they're not going to be there to give evidence.
Right.
They be there to assist the negotiation. Yes, interpretation, depending on language issues, you may or may not need the services of an interpreter. I can't remember the other feature you mentioned.
It was recording.
Yes, it's a very unusual to record the mediation process, because if it settles, there's no need for the recording. And if it doesn't settle, it's off the record, and nothing that happened in the mediation can be used by the parties in any future negotiation. So at most, what tends to happen is the mediator will take notes. There may be a time where the mediator or one of the parties said, could I just record what that expert is saying so that I can put it to my expert? But there's no court record or anything of that kind.
Okay, great. And then just lastly, before we look at settlement, how long does the typical commercial mediation take?
Well, in South Africa, it's 1 to 2 days is our kind of average. It's a little bit longer than what it's taking in many other jurisdictions. So, for example, in the UK, the average time is a day. And I think that's very, very important, that the most complex commercial disputes, which could take weeks in court, are being settled in 1 day in the UK. A bit longer here, and it might be because our parties are less experienced, our mediators are less experienced, but still 2 days compared with the kind of weeks, it's short. And while I'm on that, the incidence of settlement is very high. A figure I saw today, the figure is something like 89% of commercial mediations are settled in the UK. And I think it's something in the region of 74% on the day and about 15% in the days thereafter. And I don't know if we've got exact stats in South Africa, but my experience tells me that it's anything between 60 and 80% of commercial mediations are settled either on the day or shortly thereafter. So the settlement rate is very high.
Well, I think we know from our experience in the CCMA that settlement rates are very high. So we might have misgivings about shifting from a more adjudicative to a more facilitative process, but actually when you do it, the success rates are really there to be seen.
Well, it depends on in whose shoes you're standing. One of the things that's standing in the way is those lawyers who charge by the hour and are very reluctant to get a thing done in a day or two when they could drag it out for years. Of course, I'm being a little bit cynical, but those lawyers are increasingly being put under pressure by their clients, particularly international clients who know the cost benefits of mediation, and it's not so easy to get away with that. And even we're starting to see a resistance to the kind of lawyers in the road accident fund that wait until the last minute, either the first day in court or even during court, to finally settle a matter. That kind of stuff is not going down well. And most modern lawyers and lawyers who are conscious of how important it is to win over their clients are coming over to mediation.
There are a lot of questions coming through on our chat screen and Q&A screen, which I will come to. I want to just deal with our last question, the question that we prepared, and that is in relation to settlement. And you've really started with that, John, by talking about settlement rates. But let me ask you this then, are parties forced to settle in mediation? Is this really, does a mediator strong arm them into settlement? And what happens if they can't settle?
Well, it remains a voluntary process in outcome. There is no obligation to settle. And good mediators, as opposed to bad mediators, don't pressurize the parties. As in my days, 30, 40 years ago, we used to have judges who would call you into chambers and say, you better settle, because if you don't settle, this is what I'm going to do. That's not mediation. And we often did what the judge said because we knew what was coming. The role of a proper mediator is to facilitate a negotiation, not to give an opinion or advice or pressurize one or other party to accept a particular legal opinion or outcome. So the answer is, in proper mediation, no. And if the parties can't reach agreement, then they're free to go on to more adjudicative processes, arbitration or litigation, or even recommendatory arbitration, or whatever it may be. But we are talking of mediation properly so called, if I may call it that.
And if the parties reach an agreement, do they need, in terms of Rule 41A, do they go and lodge it with the court? Does it become an order of court? What are they? How does it feed back into the litigation process? Yeah,
the rule provides that it would feed back in and can become an order of court. It really depends on the parties. And generally speaking, a mediation agreement in South African common law is a binding agreement, provided it complies with the other requirements of binding contracts, and it will be enforced by the courts, whether it is made in an order of court or not. There are times when it is a good thing to make it an order of court, but whether or not, it remains enforceable.
Okay.
And by the way, we've recently legislated an international mediation act, which enables us to enforce cross-border mediations. And people can look at my last week's webinar on the Singapore Convention. And hopefully, if we sign that and ratify it, there will be absolutely no doubt about the enforcement of cross-border mediation agreements.
And there's a question from Jenny McIntosh here. Would you recommend that a settlement agreement be made an order of court? Yeah.
I wouldn't rate that highly, and I'll tell you why. It's a point that is often missed, is that there is an extremely high incidence of compliance with mediation agreements because they've been voluntarily entered into. So it's very seldom that a party reneges on a mediation agreement, as compared with arbitration awards and court judgments, which we know a very, very high incidence of them are taken on review, taken on appeal. You can drag out, as some people are experts in this country, for years, literally 10 years of frustration. And then when you finally win in the Constitutional Court, the company's gone out of business anyway. That is the consequence of forced outcomes. So I can understand that lawyers would say, well, we've got to have an order of courts that we can enforce it. I think it just depends on whether you can reasonably trust the other party and the attorneys on the other side, but most of the time, I don't think it's necessary.
Okay. Well, thanks, John. What we're going to do now is we're going to show a poll, which will give you the opportunity to answer a question about what you might want to know more about. Because if I look at our list of questions coming up here, they're questions that relate to mediators. How does a mediator put their best foot forward in terms of mediating in relation to Rule 41A? There are some questions in relation to lawyers, and as parties, how do you engage effectively? So we want to just find out what you would like to know more about. And as you answer that question, there is only one question. I'm going to just pick up on some of these other questions. And John, let's just do them together. There's a question here in relation to expert witnesses called to the mediation. Are the expert witnesses called by the mediator? Now, I think we touched on it earlier to some extent, but let's just go back to that. Tell us what your view is.
My view is that that doesn't happen, because also the mediator doesn't have powers of subpoena or anything like that. The mediator only has the powers that the parties give him or her. And in my experience, a mediator may say to the parties, you know, I think it would be very helpful if we could have an actuary or a medical expert, or if your respective medical experts could come into the mediation. But if the parties don't agree, then that won't happen. Also, in side meeting, a mediator may say to one of the parties, you know, it's very difficult to persuade, or for you to persuade the other party to accept this situation. I think it may help if you were to call your mediator and let me have a joint session in which your expert explains it. But it's a voluntary process, and the mediator uses all of her or his skills to get the correct information placed before the parties. It's not a court.
Okay, good. Yes, there's just another question. This role of experts in mediation. I mean, we know that there are some approaches to mediation in South Africa where experts seem to loom large. And so there's another question about experts. If experts are involved, would they sign the agreement to mediate, which contains the confidentiality clauses? So, yeah, John?
Generally speaking, they wouldn't sign the agreement to mediate, but they may well be requested to commit to confidentiality. That and also because the parties have agreed that nothing that is said in the mediation can be used outside of the mediation, even if they don't sign, there's not much that anybody can do with what they say. So not in my experience has that been a problem.
Okay. Okay, well, there are a number of other questions, and we have run out of time, reached the end of our time. There's another question about co-mediation. I think, and that relates really to the point about us having a session for mediators about how to mediate in this context. Right, so we're having a look at the poll results. Yeah, so people are saying they'd really like to know more about the implications for mediators. So we know that many of the people on this call are mediators. And so clearly we're hearing there a need to learn more about how to mediate in this new context. And then also about parties. And I think we keep saying to ourselves in conflict dynamics that we must be wary of becoming too absorbed in our view as mediators about what's best for parties, because in fact we should be starting with the needs and interests of parties, and we see that in the poll there is addressing the needs and interests of parties in the mediation process. As a user, as a user, how do I prepare and how do I choose a mediator? And many of these questions we've discussed today, we can turn around to as a party, how can they get the best out of mediation that is possible? So thank you for that. We will follow up with some of those preferences in future webinars. In fact, we have one on Tuesday. The advertising is going to go out shortly after this webinar, and it will deal with specifically the role of lawyers. And we have 3 accredited mediators who are also very active lawyers to make that connection between the role of lawyers and mediation. We'll send you more information about that. Of course, look at our website if you would like further reference or access to the documents that John referred to, agreement to mediation, models and templates, etc. But I think let me just close by, first of all, thanking Craig in the background, John over there, and if I can ask you, John, to sign us out really with some comments from you about what your dream is for mediation now that we have Rule 41A mediation in South Africa. What could it look like?
Well, I think my immediate dream is firstly that judges embrace Rule 41A and make the same use of it as their colleagues have done in many, many other jurisdictions across the world, so that mediation becomes utterly mainstream in the high courts and that nobody would dream of litigating to the end without having exhausted mediation. And I suppose my wish would be that lawyers also embrace that. But the bigger wish for me is that mediation becomes mainstream across the board. We've been talking at a very remote, high level. It's a very small percentage of the population that gets active in the High Court. There is a mass of disputes from the High Court through the Magistrates Court down to the local neighborhood to schools, where mediation could play a very, very important role in helping parties find mutual gain outcomes. And so my wish for this is that we set an example at the highest level, which can be rolled out across our whole society, where mediation becomes utterly mainstream in dealing with the multiplicity of conflicts which exist in the country. And that we don't see this as purely a high court matter for the tiny percentage of people who can afford to get there.
Right.
And it's really, I suppose, Felicity, to just emphasize it's time for South Africa to embrace the issue of access to justice. There are countries moving ahead on that, and we hardly hear a word of that from our judicial leadership, from government, from the executive, from organized lawyers. We really need to, in this country, with the population that we've got, take on board access to justice, and mediation is one of the prime ways of facilitating that.
Well, thank you, John. And with that challenge to all of us and challenge in mind, I'd like to thank everybody for participating and wish you well under lockdown. And thank you very much for attending. Bye-bye.
Thank you.